Has joined online. Our webinar today is being presented on the lands of the Wadawurrung people, and I wish to acknowledge them as traditional owners. I would also like to pay my respects to their elders, past and present, and Aboriginal elders of other communities who may be attending today. Although today's talk was prompted by COVID-19, the subject matter is not limited to the current situation and is generally applicable even after COVID-19 subsides. I'm aiming today's talk at IP managers with some knowledge of extensions of time, but perhaps with little practical experience. So what I'm hoping to do is to provide some brief practical advice without getting bogged down in legislation or case law. So I've tried to avoid details which any patent attorneys listening today may recognise that I've skipped over. The point that I wanted to make here was that unlike patent offices in other jurisdictions that have applied blanket extensions, IP Australia and IPONZ initially were seeking to rely on their existing legislative provisions for extensions of time. Griffith Hack's currently preparing detailed advice regarding the situation on extensions in other extensions of time in other countries. So if you need further details, please contact me or one of the organisers, and we'll be in touch with that information as soon as possible. But having said that, overnight, IPONZ updated its position, and they have indicated that they may also be relying on a blanket type extension of time for the deadlines listed here, which are covering most of the steps of patent examination. So, but what they've advised is that they're going to let you know through the electronic system whether you have had an extension of time, one of these blanket extension of times applied to your particular case. I don't think that if you don't receive a notification that one of your New Zealand cases has had one of these blanket extension of times applied, that you're precluded from applying under the extension of time provisions that we've talked about today. And then the other point that I was making was that IP Australia has indicated that they're aware of financial difficulties that may be caused by the current COVID-19 situation. But extensions of time to date, based on a lack of funds, have been refused. So that's they'll just tie back in with what I was talking about at the end, making sure that we link any difficulty in paying any fees that are due to a lack of control, something that's beyond the applicant or the patentee's control, and really making that clear how that's arising from the COVID-19 situation, if it's an application related to COVID-19. IP Australia has mentioned that financial difficulties might be a basis for getting an extension of time. But to date, the case law in Australia indicates that lack of funds aren't considered to be circumstances beyond the control of an applicant or patentee. So while I've mentioned that here now, I'll come back to that at the end of the talk and just touch on how we might look at addressing that under the current circumstances. So otherwise, these examples of the extensions of time falling under the Australian legislation The most common that we rely on, at least at Griffith Hack, is where there's been an error or omission made by the applicant or the patentee or its agent, and this includes employees and patent attorneys representing the applicant or the patentee. Next are the requests for extension of time based on circumstances beyond control of the applicant or patentee. And then more rarely is the provision for despite due care. Circumstances beyond control don't include employees or patent attorneys, and it describes circumstances that are outside of the control of the person concerned and that couldn't have been avoided by that person's due care. Some examples of extensions of time that I've worked on as circumstances beyond the control of the applicant or the patentee, gaining acceptance of an application during the period of time when examination of nucleic acid claims was suspended. Some people might remember that nucleic acid claims, the patentable subject matter was before the courts, and so in response, IP Australia suspended examination. So we applied for an extension of time on the basis that they were circumstances beyond our control, and that was granted, and they actually also waived the fee for us at the same time. Another example was where a renewal fee was not paid by a second co-patentee, where the first co-patentee was responsible under contract for paying the renewal fees. So the second co-patentee claimed that there were circumstances beyond their control, and that extension of time was granted. And a third example would be requesting examination, getting an extension of time to request examination when the official direction to request examination wasn't received in our office. So there are two types of extensions of time, which are discretionary or mandatory. So under the mandatory clauses, provided that the grounds are made out, then the Commissioner of Patents is obliged to grant the extension of time, whereas on the other grounds, there's discretion on the Commissioner's part as to whether or not the extension of time will be granted. But as I mentioned a moment ago, the discretion is applied beneficially. So the distinction between discretionary and mandatory requests for extension of time, in our experience, really has little effect in practice. Of the requests that I've made, only one was ever refused, and that was a long shot to start with because there was no deadline to extend. And I'll just mention at this point that renewal fees have a 6-month as of right extension of time, provided that they're accompanied by a monthly fee, late fee. Sorry, my screen has just, there we go. So in New Zealand, the extensions of time generally appear to be discretionary. So what can be extended is essentially any action with a deadline. So you'll see in this slide that covers most of the actions that fall under prosecution of a patent application. There are also opposition-related extensions, but I don't want to go into them in detail today. And you'll also note that I've highlighted two requests or two actions related to requesting patent term extension for pharmaceutical patents, because that's another favourite area of mine of Australian patent law. In New Zealand, you'll see again from this slide that the provisions are essentially the same. that extensions of time can be granted for. The difference is that in Australia, whereas the extensions of time fall under one section, in New Zealand the extensions of time fall under multiple sections of the legislation. But as I said, they cover the same types of actions. Just note that there may be some that aren't listed on this slide. The evidence that needs to be provided to support a request for extension of time is in declaratory form. In Australia, some time ago, there used to be statutory declarations, but those requirements have been relaxed, so that you can now prepare a declaration that doesn't need to be statutory and need not be witnessed either. In Australia, we also are able to file a request for an extension of time and then follow up with the evidence roughly 2 months later, because the Patent Office will issue a notice acknowledging receipt of the request. Then they'll set a deadline of 2 months. So depending on how fast they process that request, which is probably maybe up to a week, you'll have a little over 2 months to prepare that declaration to file in support of your request. In New Zealand, the evidence supporting the request for the extension of time must be a statutory declaration or an affidavit. The information that must be included in the declaration is a full and frank disclosure of all of the relevant circumstances. If you're going to rely on an error or omission circumstances beyond control or in spite of due care, how the deadline came to be missed needs to be explained. Copies of documents that support those explanations are good to include, but it's good also to avoid providing any contradictory evidence or alluding to evidence and then not providing it. There are some issues that we should avoid, and I'll come to some more of those on the next slide. It's also important to avoid any undue delay. So while it's not necessary to take all of these steps immediately, if there is some time in gathering evidence, that needs to be documented and explained as to why there was a delay between the time that the missed deadline was detected and when the application for extension of time was made. Ideally, the person who is providing the declaratory evidence will have direct knowledge of the circumstances surrounding the missed deadline. And so hearsay evidence is to be avoided. But having said that, you may have employees within a firm or a company who have left and they're no longer able to be contacted. And in those circumstances, then it's certainly acceptable to provide the evidence based on what can be ascertained from the files. In preparing the evidence, things to avoid are listed here on this slide. The first one is that if you are, for example, seeking an extension of time to gain acceptance of an application, we need to make sure that the extension is long enough to cover all of the subsequent actions. So, for example, the advertisement of the extension and then having the application accepted. In a case that I handled recently, IP Australia requested further information for an extension request that was made to pay a renewal fee that became due during examination. And until that renewal fee had been paid, the examination was halted and wasn't going to commence. And of course, while that occurred, the acceptance deadline was approaching. So the request for extension of time was filed with a calculation of how long it would take for the subsequent steps to occur. The Patent Office asked for some more information and provided 2 months to provide that information. Despite strong encouragement otherwise, the applicant provided the further information on the 2-month deadline. And the consequence of that was that the requested extension of time was then unlikely to be long enough to cover the actual time needed. Because under that, in that circumstance, the extension of time was advertised for opposition purposes, and then the examiner had to resume examination, and any objections raised had to be dealt with. So fortunately, it is possible to amend an extension request. So once we realised that the time was going to be insufficient to satisfy all of those subsequent steps, we just sought an amendment of the original request, and that went through okay. That was all accepted by the examiner. In fact, I have to say the examiner telephoned me and suggested that we put the amendment in because he felt that the time was going to be a little close. So in that extent, I think that just demonstrates that the patent officers are very willing to work with us under these circumstances. There are some acts for which an extension of time can't be granted, and essentially they are acts that don't have deadlines. So an extension of time can't be granted for a first instance application because there's no deadline to be met. So in other words, a provisional application, because there's no deadline by which a provisional application needs to be filed, you wouldn't be able to get an extension of time for that. Of course, the exception to that would be that if there'd been a self-disclosure and you wanted to take advantage of the grace period for filing an application, then that would be a relevant deadline that you would be able to seek an extension of time to meet that deadline. As I mentioned at the start of the talk, there was only one application that I've handled that was ever refused, and that came about in 2013 when we had a change in the legislation in Australia, and the aim of that extension of time was to request examination before the revised legislation came into effect, with the goal of taking advantage of the more lenient examination requirements in force at the time. Although that was of benefit to the applicant, there was no deadline, no legislative requirement for a deadline there, and so the request was refused. I mentioned a moment ago that the evidence should be direct evidence rather than hearsay evidence, but you know, as we talked about, if you can only rely on the files that you have because, for example, an employee's left, then that's acceptable. Selective evidence should also be avoided. Evidence that fails to establish an intention to perform a relevant act is also to be avoided at all costs. A recent Patent Office decision confirmed that extensions of time won't be granted where there's no evidence of an intention to perform the act by the deadline, because in those circumstances, it appeared that the applicant had just changed their mind or had been provided with an alternative strategy, and there was no evidence that they had intended to perform the act for which they were requesting the extension of time. Of course, having said that, there are always exceptions. So in another extension request that I was involved with, the patentee deliberately allowed a patent to cease by non-payment of a renewal fee, and then changed its mind and sought reinstatement. So at first glance, that would seem to be contrary to the requirements for an extension of time. But in that case, The patentee had decided to allow the patent to lapse in light of a license that was in place for that patent. However, once the patent had actually lapsed, the patentee realised that it had misread the license, and under the license it was obliged to maintain the patent for a further period of time. So based on that error, the error being the misreading of the license, the extension of time was allowed and the patent was reinstated. And that's one of the things that you'll find if you see enough of these extension of time requests, is that there's always more to the story than it appears at first glance. So you always need to do a little bit of digging to make sure that you have the facts straight and a complete understanding of what the surrounding circumstances are. And in New Zealand, there's Regulation 147 that is a fairly broad power for the Commissioner to grant extensions of time. But requests under that regulation can only be made when extensions under the other sections of the Act or the other regulations have been exhausted. So there's essentially a hierarchy of extension of time applications there that need to be exhausted first before you go for this quite broad extension of time regulation. So points to note in making a request for an extension of time are that in Australia, any extensions of time for more than 3 months must be advertised for opposition purposes. In New Zealand, any requests for extension of time that result in restoration of an application or a patent will also be advertised and may be opposed. And then there are also some limitations that occur that arise from the period of lapse of an application or in this case a patent. And they are that infringement proceedings can't be brought for any act that occurred while the patent was in a state of lapse. And then the other is that for any party that has been watching a patent and then seen that the patent has lapsed and then has exploited or taken definite steps towards exploiting the invention disclosed in or claimed in the lapsed patent, there are protections and or compensation available for those people once the patent is reinstated. So they are fairly rare circumstances, but there's certainly points to note if you are requesting an extension of time that results in restoration of a lapsed patent. The official fees for requests for extension of time are set out on this slide. So requests for extensions of time based on an error or omission in Australia attract an official fee of $100 per month or part thereof. Requests for extension of time based on circumstances beyond the control of the applicant or the patentee have a flat fee of $100, and applications based on despite due care also attract a monthly fee of $100. The official fee in New Zealand for restoration applications under the two sections are an official fee of 600 New Zealand dollars. Of course, for full disclosure, we have to remember that in seeking advice from your patent attorneys, there will be fees applied for professional services. So these are sort of perhaps the minimum official fees that would be payable. What I'm hoping to bring across from this what's turning out to be a fairly brief webinar is that you shouldn't panic. If something looks as though it's going to go wrong, either from resulting from COVID-19, which I see there's a typo on my slide there, which I apologise for, or from any other situation arising that may require an extension of time because you've missed a deadline, don't panic, because the requests for extension of time are there for a reason, and they are considered beneficially. Provided that you provide a full explanation, then the patent officers are willing to work with you and with us to ensure that your rights are reinstated, or your rights are maintained. But please contact your patent attorney as soon as you suspect that you may miss a deadline. So that's going to be quite relevant at the present time, while COVID-19 is a serious issue for all of us. And also contact your patent attorney as soon as possible after you detect a missed deadline. Because as we talked about before, it's important to avoid any undue delay in seeking to restore those rights by seeking the extension of time. Provide all of the relevant details of the circumstances, ideally in your first contact with your patent attorney. But just remember that changes of mind aren't covered unless there are more mitigating circumstances. In New Zealand, there's a requirement to demonstrate due care, so show that reminders are in place and standard operating procedures. There's less or no reliance on error or omission. While that's the most common basis for a request for an extension of time in Australia, in New Zealand, it may or may not become a factor later in the Commissioner's determination once the due care has been established. And always demonstrate an intention to meet the deadline in the first instance. I mentioned Regulation 147 a few slides ago, which are directed to extensions of time under exceptional circumstances. And it seems that test cases might be needed to determine whether this regulation can be used for COVID-19 related requests for extension of time. I think I skipped over earlier on when I was talking about Regulation 147 was that it's there's another request that's a provision that's fairly broad, or appears fairly broad on its face, but it's related only to non-delivery issues. So in practice, it may be less useful than it appears on its face. And that's why Regulation 147 seems to be attractive, but it's in that hierarchy of extensions, so may only come into play after you've investigated your other avenues. And we'll probably also have to wait a little while to see whether it has a similar action to Australia's circumstances beyond control provision. In Australia, we need to demonstrate an intention to meet the deadline, but we can also demonstrate a failure to form an intention to meet the deadline. And that's the example that I gave earlier, that the patent was intentionally allowed to lapse by failure to pay a renewal fee. There was a failure to form the intention to pay the renewal fee because of the misreading of the license agreement. So there's a fairly broad basis there for seeking an extension of time, but you have to meet one of those two requirements because, as I've said a couple of times, a change of mind without more just isn't going to be a basis for an extension of time. Best practice includes demonstration of due care. So even if you're not relying on due care per se, it is important to show that you have reminders in place and standard operating procedures that under normal circumstances would prevent that the deadline that's been missed from being missed. A full and frank disclosure of all of the surrounding circumstances are needed for all requests for extension of time. If you are relying on an error or omission, in short, somebody needs to take the blame, and somebody needs to admit that they've made a mistake or they failed to take some action. That's really the only way that one will gain some traction. You might find that if you're dealing with US attorneys, there may be some reluctance there, I guess, for liability issues, but it's certainly something that's required for those requests to be granted. Circumstances beyond control, I've touched on this a few times, that to date, the case law indicates that a lack of funds are not sufficient to establish circumstances beyond the control and for an extension of time to be granted. So what you need to know specifically for Australian extensions of time in relation to COVID-19, I would recommend requesting an extension due to circumstances beyond control. And the reasons for that are, one, you can request that in advance, and by requesting it in advance, you can also establish your intention to meet that deadline. The request can be amended if for some reason the initial period requested is not long enough. And I think we can all appreciate that under the current circumstances, we don't really know how long the situation is going to go. So you could easily ask for a 3-month extension and then find that realistically you need a 6-month extension. So that could be amended readily under that provision. There's a flat fee of $100, so you're not paying per month. It's simply the initial $100 to cover the request. You could certainly ask for a refund or for the fee to be waived. Whether or not that would be granted is uncertain, but there's certainly no harm. It wouldn't affect the consideration of the request by making that of the extension request by making the request for a refund or waiver. And I think perhaps the most important thing here is if you are making a request under based on circumstances beyond control, because of the issue that a lack of funds are not circumstances beyond control, I think that it's going to be very important to emphasize how missing the deadline can't be avoided by your due care. And so making that extension beyond the fact that it's not your fault that you don't have the funds available to pay the fee, whatever fee it is. But in fact, it's something that's completely unavoidable and out of your hands. And I think that that's going to be needed to take that extra step and move away from what's the current position of the case law that's precluding extensions of time to be granted based on circumstances beyond control, where it's claimed that the lack of funds is the circumstances beyond control. So now I'll take some questions. I've actually gone through that a little faster than I was anticipating, but I'm happy to hear any questions that you may have.
So I'll read these out to you, Malcolm. So regarding COVID-19 EOT, I've had questions asked about extensions of time for financial reasons, delay incurring costs, and general market uncertainty. How do you believe these circumstances would be considered?
Sorry, was that IP Australia or IPONZ?
Perhaps go through both real quick.
All right. Sorry, Can you just repeat the question?
Regarding COVID-19 EOT, I have had questions asked about extensions of time for financial reasons, brackets, delay incurring costs, and general market uncertainty. How do you believe these circumstances would be considered?
Yeah, so I think that is one of the main issues is that it's essentially untested. They've indicated, as I went back to those early slides, they've indicated that they're aware of the situation and they're essentially encouraging applications to be made. But the evidence that we've got to date is that there'll need to be a strong indication as to why COVID-19 is affecting that ability to meet those deadlines and the ability to pay those fees. I think that in the grand scheme of things, knowing that the Patent Office is wanting to work with us to maintain rights, I think that there'd be a good chance that they get up. It's just that the untested waters. But I would make every effort to explain how the COVID-19 is affecting the ability to pay. And I think that provided you make that clear, that link, that there's a direct link between COVID-19 and the inability to pay any fees that are falling due, then I think that you would stand a very good chance of the request for extension of time to be viewed favourably.
Our next question is, have you seen an increase in applications for extensions due to COVID-19?
In honesty, I haven't seen one yet. So no, but I don't think that means that we're not going to see them very shortly. Perhaps if we may not see them for New Zealand if they do apply, a blanket extension that they've indicated that they may be. But to date, no, I haven't personally, and I'm not sure that I'm not aware of any. No, but they may come through perhaps.
Our next question, in your experience, how readily does IPONZ grant EOT as compared to IP Australia under circumstances of error or omission?
I have to admit I've had very little interaction with IPONZ on extensions of time, but with IP Australia, I find that they're really ready to work with us. And as I mentioned, I've only ever had one refused in Australia. And even if you don't provide what IP Australia considers to be satisfactory information, they'll always give you an opportunity to provide that further information. And I don't see any reason why IPONZ wouldn't behave in the same way.
So our final question. Earlier in the talk, you mentioned a situation where you didn't receive a direction to request exam from IP Australia. Is there any reason why you chose circumstances beyond control rather than patent office error as the basis of your request, given that the latter provision would not provide the Commissioner with discretion?
Because there was evidence that that we had there was evidence that it had been sent out by IP Australia, and then there was some question as to whether or not it had been received and processed correctly, and I think that was why we took the safer route and admitted, well, I don't know that we admitted, but we took the safer route of saying that there was a more likely an error in receiving and processing the direction rather than the direction being sent or being lost in the mail, particularly because they're being sent electronically now. So it's a little harder to rely on I think the lost in the mail than lost in the email. So I think it was just the safer option under the circumstances.
And that was our final question.
Well, thank you for attending. If you have any further follow-up questions that may occur to you, or if you want some more information about extensions of time in other countries, then feel free to get in contact with us. Thank you.